Hello, students. This is our last lecture on constitutional law, Chapter 9, Trial and Punishment. Now, I realize these video lectures are really designed to kind of give you just an overview and also to see some areas of concentration. Sometimes it's easy to get lost in all the reading you have to do in individual cases. So it is important that you have kind of a broader framework of how you should look at these areas of the Constitution, and also when you apply them to an exam question, try to keep like basic principles in mind. Normally these basic concepts are going to lead you to the right answer if you don't get yourself tied up into minutia of little exceptions to it. Normally the exam questions are not going to be that difficult. They're designed mainly for major concepts. So that's my basic goal in these video lectures. So let's look at trial and punishment. And when we look at this, we're looking now at two basic amendments, and we're looking at the Sixth Amendment for the trial, and we're looking at the Eighth Amendment for punishment, because once the conviction has taken place and we're moving into the punishment, and after the sentence has been handed down, we're into the punishment stage, or even during the sentencing stage. That's all about punishment. And we come under the Eighth Amendment protections, basically cruel and unusual, which is one of the basic standards. You can't have a cruel and unusual punishment. When we look at the Sixth Amendment rights in regard to the trial, we're looking at the right to speedy trial, public trial, the right to confrontation for adverse witnesses, the right to a fair trial, and that's before an impartial tribunal, and the right to a trial by jury. Now, under the Fifth Amendment, there's a Fifth Amendment protection also, and that's a little different because that's basically your protection against double jeopardy. And the reason that's different and why it's the Fifth and not the Sixth is that double jeopardy protection actually kicks in at the stage where you have been tried and you've been found not guilty and you're being retried again, but that means you're going to be usually arrested, recharged. So we're into areas in which your Fifth Amendment rights are being imposed upon at something that not just the trial, but the fact that you're going to be arrested, you're going to be confined, you could be confined again. So this right to double jeopardy is a Fifth Amendment right. The rest are Sixth Amendment rights, except for the protection against cruel and unusual punishment, which is the Eighth Amendment. Make sure you understand which amendments these protections relate to. Now, we'll start out with the Fifth Amendment protection for double jeopardy. And under this, basically, and the reasoning, there's a policy statement behind your protection. It's the idea that the power of the government, if they could retry individuals, they could just break you down as a defendant because of the huge financial resources that a trial or preparing for a trial could cost, that any type of confinement prior to the trial and even during the trial, at that point you'd be unable to earn a livelihood. So that would give an enormous, it'd be impossible to have a fair trial if you're going to be recharged. There's a policy statement that once you've been tried, found not guilty, the government, as a general rule, is not going to be able to try you again because they'll violate that Fifth Amendment right. Now, the Fifth Amendment right also kicks in that you cannot be punished in two different ways, more than one punishment for that one offense. And we'll look at why that normally comes into play when we talk about civil proceedings in which they're not a punishment, but the idea of having two separate punishments for the same offense is also double jeopardy after you've served your time. The ingredients that are necessary for protection against re-prosecution are three. One, the earlier prosecution must have progressed to the point where jeopardy had attached. Now, what this means is that for you to be for the double jeopardy provision to be important to you, it doesn't mean you have to go all the way through the trial and to have been found, not guilty, and then you're being tried again. That the point where you are in jeopardy, where you've also expended resources, been put under the stress of jeopardy, actually takes place at an earlier stage, and normally that is going to be when the jury has actually been impaneled, and jeopardy at that point. And again, think what jeopardy, it means that at that point, can the government, for example, take some kind of action and then come back and retry you again, bring charges again. Well, once the jury has been impaneled, that means at jeopardy, there's a good chance the government can't do that. Now, if you're before a judge, a bench trial, what's called a bench trial, once the first witness has been sworn in and the judge begins taking testimony, jeopardy attaches, and it's the same basic protection. For example, for the judge to, at that point, or for the prosecution, I mean, to step in and say, well, we don't have our witnesses available, we have some problems, and we're going to dismiss our charges, and and we'll start over. Basically, once jeopardy is attached, there's a good chance, the probability is very high, they're not going to be able to retry. Now, for that particular, it's just the second provision. You can't be retried for the same offense. So jeopardy has to have attached. Then you can't. Then they're trying to retry you for the same offense. Now that brings up another question: is what is the same offense? Obviously, let's take bank robbery for an example. You're tried under the statute for robbing a bank, and during the proceedings, the prosecution decides that we're having a problem, or let's take it this way: you actually you go all the way through, you're found not guilty of bank robbery, and all of a sudden you're out walking around, the defendant's out there, he's free, and the prosecution says, well, we're now going to charge you and with carrying a weapon during the commission of a felony. As a separate charge for that particular provision. Trying to find other charges that, and this is where there's a test here, because we're talking about two basic tests to determine whether or not the jeopardy should attach. The normal test was the test that's called the same elements test, and that means that if basically that you have two different prosecutions, if the elements of the penal code that are being charged, if there's a separate element that has to be proven that's different from the first element, then you can be charged again with that particular violation. Because it is an element that's different from the first. Now, this is the federal rule, and it's also the rule in most jurisdictions, where the bank robbery example, charged with bank robbery, found not guilty, the government comes back at you again, and they now charge you with some another statute that, even though it relates to the same transaction, this statute has a different element that has to be proved apart from the original charge of bank robbery. That could be example of receiving stolen property, the weapons violation. If it has a different element, then you can be charged with that element, and jeopardy you will not be protected under the Fifth Amendment in those circumstances. There's another test used by some jurisdictions where they look at, is it the same transaction? It means that if you have a variety of statutes, they all relate to the same action, like robbing the bank, then they have to all be charged during the initial trial, and they cannot be charged later. It's all or none. But the majority rule is the same elements test. So but basically, you need those two things. And the last one is that the prosecution, for jeopardy to protect you, has to be brought by the same governmental entity. It means that different states, a crime that they have, that you violate the law of two different states, you can be charged in both states. Or if you violate federal law and state law, you can be charged both by the federal and state government. So different sovereigns. Double jeopardy applies the one sovereign test, basically. You have protection against one sovereign under the double jeopardy provisions as set out by the Supreme Court. Okay, we went over the test, the same sovereign entity, and the idea of multiple punishments for the same offense. It prohibits more than one punishment for that same offense, but that does not include civil penalties. And that's civil penalties can include prohibitions, can include the imposition of a variety of restrictions on you. They can even include confinement. If it's for civil purposes, that is not related to actually punitive measures, that they have other reasons for it, like treatment, where there's a civil confinement for treatment. That does not come under, that is not double jeopardy for civil. If it's considered civil and not a punishment, then you can have two basic provisions involving sentencing as long as the one is not considered a punishment. If the goal is non-punitive, that was the goal. All right, let's move to the Sixth Amendment provisions, the various rights at trial. The right to a speedy trial basically means that the government can't just drag their feet once you've been charged, once you've been formally charged and the Sixth Amendment right is attached. You're an accused, delays. Basically, if the delays are excessive, they can violate this, and you've been prejudiced by it, then that basic right to speedy trial can actually cause your charges to be dismissed. The public trial, also guaranteed by the Sixth Amendment, and public trial exceptions, generally, the judges occasionally can close their courtroom to the public. It's very rare. Only under most urgent circumstances can they exclude the public. One of the common examples of this is where there's evidence that there's a high risk of safety for the defendant to have a public trial. Numerous threats, crime that just shocks the conscience of the nation, the fear that people would actually try to kill the defendant during the trial. That could cause, and that would be constitutionally permissible for a trial judge to decide to close it to the public. There are some exceptions. There's an exception to the public proceedings. Remember, this includes pretrial. They also fall under the right to public trial. Suppression hearings generally are open to the public, but under certain circumstances, it is constitutional for a judge to close suppression hearings, but that requires, again, certain circumstances that they have to make findings as to why those circumstances are being met. I mean, they have to actually justify why they did it, but it can be done. The grand jury proceedings are an exception. Grand jury proceedings are private. They do not fall under the public trial protections of the Sixth Amendment. The media and the public have the right to attend these trials. If you're an accused, you have the right, obviously, to be at the trial. The only thing that you'll see this sometimes in cases that maybe you've seen in court or been involved in or seen on TV. If you're so disruptive, if the defendant is so disruptive, then that defendant can actually be taken out of the courtroom and be withdrawn from that. Now, judges are very hesitant to do that, but that is constitutional if they are so disruptive. Also the defendant, obviously he doesn't show up for trial. That's his decision. One other exception in regard to the ability of the defendant to confront the witnesses. Generally, that's a very, very strong. That will definitely affect the trial, but the Supreme Court has allowed that right to confront witnesses by the defendant in regard to certain child witnesses. And they've set out some restrictions on that. Normally, one of the things is the one-way video where the child can testify, but the defendant can't. The child doesn't see the defendant. And the reason for this is if the court has been convinced that there's enough evidence that the child, his testimony would be severely impacted by having the defendant confront the child. So that is constitutional under certain circumstances. Fair and impartial, the right to fair and impartial trial. That's both the jury trial and the bench trial. So the judge also held to the same standard, fair and impartial behavior. No personal stake in the outcome, no animosity towards the accused. You often see this, and this provision will often be advanced later after a trial. You also see the defense sometimes laying the foundation for this fair and impartialness when you see encounters between the defense attorney and a judge, where sometimes the defense attorney is actually trying to show that the judge is not being fair or impartial, and that will be raised later on appeal that that particular right was violated by the judge in not being fair and impartial. The jury, evidence that might arise at something in the jury that showed that they were not fair and impartial. Again, that basic objection to the trial, advance to the trial later on appeal, can be advanced as a breach of a violation of the Constitution, which will cause a reversal. Okay, pretrial publicity. Pretrial publicity is a due process issue. It's whether or not there's been so much publicity out there that it fundamentally makes an impartial verdict impossible. And this can be handled. This comes up, and again, in big trials, big cases, they handle it in a variety of different ways. But normally, if that arises to the area where it's a possible constitutional violation, the court is going to look at whether it was prejudicial. How much publicity was there? Was the publicity actually prejudicial to the defendant? How close did it occur to the time of the trial? And what types of attitudes may have been revealed by jurors during the voir dire when they were selected for the jury? Sometimes you'll see the trial judges try to cut down on pretrial publicity, and they use a variety of measures, and those can involve constitutional issues. When judges try to impose gag orders, restrictions on the ability of the press, that's almost uniformly, that's going to be a violation of the press First Amendment rights. That's unconstitutional. However, There are other areas in which the judge's attempt to restrict what happens or what is said have been held to be constitutional. Closing the courtroom, again, questionable constitutionality. They have to be strong reasons. They have to be advanced by the judge in justification for closing it, or just a uniform policy, or closing a courtroom without valid reasons. We're not going to will be unconstitutional. Orders directing officers of the court, the attorneys, law enforcement personnel, from making comments about the case. Again, you often see this done where judges impose gag orders on the prosecution and the defense and law enforcement bodies. That is constitutional. And that, again, that is a relatively common in trials that involve the potential for a lot of publicity, in which they realize that the publicity can be exacerbated, by comments being made by the officers of the court in this case. Very common. Now, the ABA guidelines, there are guidelines for what you can say if you're an officer of the court or you're law enforcement. There are guidelines out there for what would be considered basically a breach of decorum in saying certain things that could violate, if it was extreme enough, could actually affect due process of how the trial, of the defendant's ability to receive a fair trial. Trial by jury, under federal system, 12 jurors. It's based on common law history, where they selected 12 jurors. That the Supreme Court has not held that is a requirement for states. States, as long as they have 6 as a minimum, it's constitutional. The unanimity of a verdict in the federal system has to be unanimous. In states, the Supreme Court has not held that that's necessary either. Less than unanimous verdicts are permissible in state jurisdictions. The preservation and disclosure of evidence is another issue that comes up in regard to a fair trial. And we're looking at what's often called the Brady Rule, and that's the idea that for the defendant has a due process right to a fair trial, and that it can be violated by the prosecution's failure to turn over evidence that is material and that is exculpatory in nature and favorable, although favorable to the defendant. So basically, if it's in the prosecutor's control, now again, a Supreme Court decision, prosecutorial control does not includes information that is in the hands of the law enforcement officers, crime labs, and it includes information that the prosecutor may not actually know about, but the prosecutor is, the duty is imposed that he should have known about it. So that the actions of the police, for example, in not reporting information that's material, that's exculpatory, and exculpatory for the defendant, that knowledge of the police is going to be imposed upon the prosecutor. Irrespective of good faith or bad faith. So, total accident, if it's favorable to the defendant, material, it has to be material to guilt or innocence. Basically, the guilt or the sentencing, the materiality of it is important. Then if defense finds out that evidence was there, then that will basically, again, that violation will cause a reversal of the sentence because the unfairness of the trial, since evidence that was exculpatory was not turned over to the defense. To be favorable, we're looking at that evidence. When we talk about to be favorable, it must either negate the defendant's guilt. So all evidence does not have, every bit of evidence that the prosecutor has or that the police have does not have to be turned over. Again, the evidence that is, a lot of times you'll see this, you know, when I was an investigator, I sometimes would be upset we're returning so many things over to the defense, but generally it has to be evidence that, not generally, the rule is it has to be material in nature, it has to be exculpatory. Lastly is the duty to preserve evidence. And here the police have a duty to preserve, but negligence is not really that you will not have a constitutional violation unless the police action was intentional. Negligence is not sufficient for basically evidence that they destroyed through sheer negligence. It has to be intentional before that to be considered a constitutional violation of due process. The Eighth Amendment requirements, we're looking at probably the one that you should realize for testing purposes, that the death penalty currently under the Supreme Court decisions cannot be imposed on children under the age of 18, the mentally retarded, or the criminally insane. The death penalty only applies to individuals who have actually murdered somebody. The Eighth Amendment imposes restrictions on prison officials. They have to refrain from unnecessary and sadistic applications of force. That's a much looser standard than the police provisions where their force has to be reasonable. Prison officials' force can be unreasonable as long as it's not unnecessary and sadistic. That's extreme. It's because in some cases, in confinement situations where the Fourth Amendment is not an issue here in regard to seizure, but the Eighth Amendment is, the standard by the court has been unnecessary and sadistic, and the prison officials have to provide for prisoners basic needs, basic human needs, and that means they have to have a decent habitation, freedom from attack, and care for serious medical needs. And their basic standard they're held to is they can't be deliberately indifferent. And that's it. Good luck on your coming examination, and I hope this helped a little bit. And thank you for listening.